included in second or third shall be sufficient qualification for enrollment of any state register or of homeopathy. No person other than practitioners of homeopathy who possesses a recognized medical qualification and is enrolled on the state register or the central register of homeopathy shall hold office of the homeopathic physicist or any other office in a government or any institutions maintained by a local or any other authority, shall practice homeopathy in any state, shall be entitled to sign, authenticate a medicine fitness certificate or any other certificate required by law to sign or authenticize any of the any authenticized by a duly qualified medical practitioner, shall be entitled to give any evidence at the inquest of any court or law or any expert under section 45 of the Indian Evidence Act. Now, Lordship, this section gives ample scope to qualified practitioners only to be engrafted in the central list. So, I being a person without the qualification cannot approach directly to the central list. Only the scheduled B second and third. These are the practitioners who have got a requisite degree from a college. Now, there is a submission which has been made that I can approach the central list, central registry. That cannot be done by me.
Yes, that is good.
So the only option left with me is to come under the Act of 1997, and that is Nagaland Act. Now, Lordship, may kindly see the Nagaland Act now.
Page.
Lordship would find that on page number 10, Lordship. 9, Lordship.
Yes.
Lordship, rightly been pointed out that this act prevails for practitioners in Nagaland. It has been rightly pointed out. Now, Lordship, what is the factual matrix? We have been practicing in Nagaland. And during the time of coming of the act, we have been practicing here. And we had to obtain license under this act. Now, Lordship, since we were a person who were not qualified and had been practicing through our customized way of practice, we were given a special class. That class is Class B. Lordship, kindly see what is the class. Section 9, Lordship.
Yes.
There shall be two classes of registered homeopaths, Class A and Class B. Now, since we are Class B, I would like to take your Lordship to what is Class B at page number 13. One who has been engaged in practice of homeopathic system of medicine as a principal occupation for a period of not less than 5 years, immediately before the date of coming into force of this act, provided that a person shall have passed an examination to be held by the board in a manner provided by the regulation upon an application for registration of his name to be made within a period of 2 years from the date on which the act has come into force. Now, Lordship, what is the condition precedent? I have to be practicing from previous 5 years, which would be in this case 1997. So it would be from 1993, number one. And number two, I have to file an application before the registrar and get myself enrolled within 2 years. And that makes 1999. So Lordship would see.
Plus, you have to pass an examination.
Plus, I have to pass an examination. Now, Lordship, in page number 11, what is the section 5, which denotes compulsory registration? Within 1 year from the date of a gazette notification of the constitution of board, a person practicing homeopathy shall report his name, address, qualification to the chairman of the board for the purpose of registering his or her name in the name provided therein. Now, that this section is in consonance with the sections previously read, that is section 9. Subsequent to that, I have appeared before the board, given my address, given my name, given my occupation, and get myself registered in the year 1998. That is within the prescribed time. Now, how do I say that, Lordship? Lordship may kindly see Annexure 1 of my writ petition.
WBC?
WPC number 180. Lordship would find
Annexure?
Annexure 1, A.
Page.
It starts from 42 onwards.
Yes.
So Lordship would see that all these annexures are the registration certificate which was been issued in the year 1998. Which means one thing is clear, Your Lordship. In the WPC number 180, all the petitioners were registered in the year 1998.
Achha, just before,
Lordship.
all these petitioners in the writ petition,
Yes, Lordship.
in your writ petition,
Yes, Lordship.
are they all practicing in Tamil Nadu now?
No.
Some are,
Different areas in India. They are practicing. But the condition precedent is that is, I'm coming to it. What is their state? It's a very peculiar state. I'm just coming to that. Now, Lordship, from 90, before, since this certificate was issued, now we have to presume that they are practicing since 1993, 5 years before, 2 years after commencement of this act. So, if we consider that these people are practicing from 1993 onwards in the state of Nagaland because of these certificates, now, Lordship, what has happened basically, everything was going fine till 2012. A renewal has to be done yearly. Yearly registration was also given. Registration was also done. We have paid the requisite fees and we were practicing till the year 2012. Now, 2012, the problem starts. The problem not with us, but with the respondent board. It has been submitted at length, and Lordship has also noted down what were happening in the board from 2012, 2010 till 2016. There were anomalies, board has changed, so many representations has been issued. Some people found some anomalies between the parties who have already been registered. So hundreds of things were happening. But one thing which was not happening was renewal. Renewal of the previously empaneled homeopathic practitioners were not renewed. Why? Because of these anomalies. There was no board, there was no chairman of the board, board changed, everything happened. From 2012 till 2016, there was nothing. Now, since there was no registration, no renewal, what do? I have to leave the state of Nagaland and I have to practice everywhere else except Nagaland. It is also not the case that I can apply directly to the central list. The Nagaland board has to send the list to the central board, which has not been done. And if it was done, there were anomalies. Central board did not accept it. In that particular circumstances, what do? I had no other option. I was here and there doing nothing. Now, in the year 2016, this notification came. Now, this is the factual part. Till now, it was the factual part that this is the state of affairs of the petitioners. Now, Lordship would see what has happened. Now, I'm not denying the fact that the board is trying to do well or whatever has happened wrong. I'm not denying the fact, and I appreciate that also. But that would not mean that they would merely issue a notice. This is a case of the petition of the respondent board that it's a simple notice, argued repeatedly. It's a simple notice. My problem is that it is a simple notice. For them, it's a simple notice, but for me, it is life changing. Lordship, may kindly see what is the simple notice. Lordship, may kindly see the writ petition in page number 137.
Yes.
May I just read? Annexure B, Lordship got it?
Yes.
Public notice. So first of all, this is not a mere notice. It is not just a notice. This is a public notice. The Nagaland state government, in consonance with Section 24 of the Nagaland Homeopathic Medicine Act 1996, which confers the exercise of powers to the state government to make rules from time to time consistent with the Act, invites for renewal of Class B homeopathic registered in the Board of Homeopathic System of Medicine Nagaland within 3 months starting from August 2016. Now this, Lordship, whether it is permissible. I am not denying the fact that the board has the power to make rules, state government has the powers to make rules. But whether this public notice is a rules, Lordship may kindly see section 24
Of?
of the Nagaland Homeopathy Act, Lordship, of 1997. Page, page 18, Lordship. Lordship. Page 18. Power to make rules. The state government may from time to time make rules consistent with the Act for carrying out the purpose of the Act. Rules were already made. Consistent from time to time in the year 1998. It has been submitted by the Council for the Respondent number 1 that rules of 1998 were there and there were some stipulations regarding what is address and what is the name and their specific procedure has been prescribed. So admittedly, rules were made in the year 1998. Now, can a mere notice be a rules?
Yes.
Lordship may kindly say again, this is a public notice. Is there no difference between rules and public notice? Any act will be accompanied by a set of rules. And that is what section 24 is. Now, Lordship would know that this coming of the CAA, the government has framed the act and the act has been made public. But rules are not made. Rules are still there. So the CAA could not run. It is still at the stage where it was before amendment. The rules has to be made, rightly or wrongly. Under section 24, the state government has the power to make rules only. Now, Lordship, it is correct that they have quoted a section 24, but section 24 will not empower a secretary to the government of Nagaland to make rules. Rules has to be made, it has to be published, and it has to be published in an official gazette. And it would be, in my humble submission, like this. It would be, the rules would be called like this. Nagaland Homeopathic Medicine Rules. If it's in the year 2016, it will be 2016. It cannot be a public notice. Now, public notice can be regulations. But what are the regulations? Lordship may kindly see page number 17, section 23.
Yes.
Making of regulations. Now, Lordship, the other day I was searching in the internet. I was just saying what is the difference between regulation, notice, and rules. I have seen that regulations are a set of rules which can be made by the executives or the quasi-executive bodies, but that has to be a trust of official gazette or something which empowers them to make these regulations in the parent act. Now, Lordship would kindly see section 23. If I may just take your Lordship to page number 18, not 17, the operative part. Subclause 3. All such regulations shall be published in an official gazette. So, regulations can be made by the secretary to the government of Assam. There is no problem. Or government of Nagaland. That's not a problem. But the problem is, it has to be published in the official gazette. Now, the respondent number 1 board stand, that is a mere notice, cannot stand the eye of law, Lordship. Maybe they have done it for a good cause. That's a different aspect of altogether. But it cannot stand the eye of law, saying that it's a notice, it's a public notice, you come. If you are doing a verification, if your causes are normal, or if you wanted that this board should function properly, and there are a lot of anomalies, serve individual so-called notices. Public notice has a different meaning altogether. Why all these people who are a part of the board be not called by a so-called notice? Come, you give whatever you want. Show me where do you, what is your landed properties in Nagaland? Show me from where have you practiced. Why are individual so-called notice not been issued? Why a public notice? Public is public. And this is not public. These are people, they are a specific group of people, homeopathic practitioners. They can specifically send notice if their ideas were noble and their board has changed, they want to bring up changes, they issue notice to the members of the register, the people who are enrolled themselves in the register. But they have not done that. After coming of the public notice, I'm coming to the rest part of the public notice, but till now I have just read one sentence. Lordship, may kindly see page number 138 of my writ petition. 138 of my writ petition.
Yes.
These are all notices served by us to the registrar. What have you done? So, I just would like to point out 144. These are all same notices. So-called notices, legal notices issued to the register of respondent number 1 board. May I just read? Page number 144. That I obtained a certificate of homeopath under class B as mentioned in section 9 of the Nagaland Homeopathic Act so and so on 11/2/1998. I got registered my name from the Board of Homeopathic System of Medicine registered under so and so. And after getting the said certificate, I started my profession as homeopathic doctors in the state of Nagaland. In connection, it is necessary to mention that since I passed the examination conducted, the Board of Homeopathic System of Medicine in Nagaland, the said authority registered my name as a homeopathic doctor in the register. A Xerox copy of the said certificate is annexed with letter A. After getting such registration from the board, I have started my practice as a homeopathic physician at Nagaland as well as other states independently. During continuation of my profession, the Board of Homeopathic System of Nagaland renewed my license during the interval period of 5 years in connection with norms and statutory provisions, and my professional license for practice has been renewed by the state authority up to the year 2013. In the year 2014, when I approached the Board of Homeopathic System of Medicine Nagaland for renewal of my professional license, the concerned authority of the board informed me that due to some of inner dispute which cropped up between the board and the government of Nagaland, the further process of renewal has been kept in abeyance temporarily, and accordingly I have been advised to approach the said authority for such purpose at a late stage. In such situation, I have no other alternative but to leave Nagaland, in as much as, according to the knowledge, being good citizen of India, I thought that I should not continue my profession as homeopathic physician in the state of Nagaland without getting renewal from my professional license. This is what I have been saying, Lordship. On or about 15 February 2019, one of my colleagues who was the homeopath practitioners and practicing at Nagaland apprised me about a public notice under reference, and I have been informed for the purpose of getting renewal of my license and also for practicing in the state of Nagaland. A residential certificate issued by the respective district administrative authority of Nagaland is to be submitted. As after getting such information, I become thunderstruck and collected the said public notice. This copy of the same is so and so. I submit that the Section 15 of the Homeopathic Central Act conferred the right on those persons of possessing qualifications, including the second and third schedule, so and so as to be enrolled person to practice homeopathy in any state. Since the public notice under reference create a bar to practice in the state of Nagaland to those physicians who are not permanent residents of Nagaland, the said provision directly attract the letter and the spirit of Section 2B of the Section 15. On considering letter and spirit of Nagaland Homeopathic Medicine Act 1996, it appears that the said Act also never imposed any such restrictions for practicing in the state of Nagaland as a homeopathic physician. In light of the letter and spirit of the said Act, it appears that the public notice a notification under reference of practicing in the state of Nagaland as mentioned in subpara so and so, also contrary to the Nagaland Homeopathic Medicine Act 1996. Law is well established that as an executive order cannot override an act or rule in the instant case, since the purported notice under reference and the letter and spirit thereof, as mentioned in subpara 1, subclause B, affects the letter and spirit of subsection 2B of section 15 of the Homeopathic Central Council Act 1973, the public notices under reference is seen to be inoperative and has no legs to stand in the eye of law. So, Lordship, these are the initial notice. Now, Lordship would revert back to the public notice, Lordship. I would just start from where I stopped. They are to come personally for verification with required relevant documents or qualifications to practice. Section 10, subclause 1 of the Nagaland Homeopathic Medicine Act 1996 states that the registered homeopaths shall receive license to practice homeopathy in the state of Nagaland, provided Class B practitioner qualifies the following. First of all, those who are presently practicing homeopathy in Nagaland, which, Lordship, I am not. Not because I am not. It's because renewal was not done on behalf of the board. Those who are residing in Nagaland during the time of his registration, as provided, have the following original documents as proof of residence in the state of Assam, in the state. The permanent residence certificate issued by the respective district authority of the government of Nagaland. Now, Lordship, this implies I need to have an PRC, and I have to have a landed property in Nagaland. Now, if it is an admitted fact that as per Section 2, I do not have the land revenue manual, but as per Section 2 of the Nagaland land revenue manuals, no person from outside the state can buy land in Nagaland. That being so, how would I have any land documents relating to my permanent residence here? That is one aspect. The second aspect is that the Dominion of India do not recognize any domicile or any PRC. PRC is only for a limited aspect when a person goes to students who goes to study any other course. Since he has shifted from the state of Nagaland or Assam or anywhere to the place where he would study, only for that limited aspect, I think in Assam they issue. But other than that, no authority can issue PRC or Dominion certificate. It is well established that everyone is a Dominion of India. Nobody is a different Dominion of Assam, Nagaland, Manipur, Delhi. Nothing is like that. All are Indians, all have the same identity. This cannot be allowed. Address proof of their clinic, place of practice, colony, local Gaubura or local authority. How would I do that? Again, Lordship, trade license. How would I get? 2013, I'm not practicing. These are the things that had this notice been issued in the year 2012, then I would have been able to. You have stopped your functioning. 3 years you make me wait, and then you want me to produce something of 2016, which I'm not able to. Where would I go? Now, the problem with the petitioner is not limited to that. Now, the actual problem starts. What would happen if I'm not able to produce these documents. Lordship has to see that. If I'm not able to produce any documents, all these documents, I would not get my renewal certificate from the Nagaland State Board. If that happens, I would be no longer eligible to make application in any place in India.
Why?
Because the Nagaland State Board has to forward my name after registration in Nagaland to the central board. Once I become part of the central register, as per the approval of the government, this submission has already been made by respondent number 1. I can choose any other dominion. I can choose any other state. If I do not have license here in Nagaland, I will not be able to choose my place anywhere in India.
No, you can apply in the state where you are staying now.
That I cannot do, Lordship. I have already.
Why?
Lordship, may kindly come again, Lordship. I have already placed that. Lordship, may kindly come to national. This central act.
Central line.
Yes.
Page.
Lordship, page
Yes,
number.
yes,
Lordship,
I've got it.
50. Page number.
Section.
Section 15. 20, page number 29.
Section 15.
Yes. Subject to other provisions contained in this act, any medical qualification included in the second or third schedule shall be sufficient qualification for enrollment on any state register of homeopathy. Qualification, Lordship. Section only with respect to second and third. Lordship will come to section page number 37. These are all schedule, second schedule and third schedule. These are all list of universities. These are all in respect to class A, which has been described in the Nagaland Homeopathy Act. So if I am not given a registration here or renewal here, I will not have any way to approach the central register. And I will not
No,
be.
let us read that.
Lordship.
Subject to other provisions.
Lordship, I'm coming to that, Lordship. Oh.
Second or third stage.
Yes, no other person other than practitioners of homeopathy who possesses a recognized medical qualification and is enrolled on a state register or a central register of homeopathy shall hold office of homeopathic so and so. I am restrained by this public notice.
How are you restrained by this?
Lordship, I may not be able to be very clear. Lordship would see section 15.
Yes.
Section 15 says that you can practice anywhere in India and also get registered under state bar, state register if you have medical qualification on second and third schedule. I do not belong to second and third schedule. I am a class B homeopath.
So what? There must be some prescription with regard to class B.
That your Lordship would find at the Nagaland Act, Lordship, in page number 16.
1 minute. Here in the Central Act, there's no provision for class B.
Lordship would see section 26 then, Lordship. It will be clear. Page number 33. Privileges of person who are enrolled on the central
No, that I've seen. But so
So
far
my
as
road-
state register is concerned,
as state register is concerned.
is there a bar for you to register in any other states?
Yes, because only.
Where is the bar?
Yes, I'm coming to that. What is the bar? Lordship would see 26B, 26(2). Subject to provisions of subclause 3 or subsection 3 of section 15, Any person whose name is for the time being born in part 2 of the central register of homeopathy may practice homeopathy in any state other than the state where he is enrolled on the state register of homeopathy with the previous approval of the government of the state where he intends to practice. My enrollment in Nagaland is absolutely essential for me to continue further. I will not be able to practice in Tamil Nadu or Kerala or Delhi if I am not enrolled here. This is my way to go to the central list.
No, you can get yourself enrolled in Tamil Nadu.
Lordship, no, Lordship.
Why?
Because I am Class B, Lordship.
Class P is the requirement that only in
Yes.
Class P only Nagaland is the authorized
Yes,
state.
yes, Lordship.
Where's that provision that says that Nagaland is the only authorized state to register Class B homeopaths?
Lordship, for that also, Lordship, I am the Class B. Now, in Tamil Nadu, I will not be able to go and apply because previously I have not been. Right now, as per the act, the Class B will not be there. Only with regard to schedule second and third of the Central Act will cover.
Schedule 2 and 3.
Yes,
That pertains to Class A.
that's Class A.
I'm talking about Class P. Your position.
Yeah, my position will not be covered by any other act except this Nagaland Act, Lordship.
Where does Nagaland Act debars you from getting enrollment in other states?
It doesn't.
Then
It opens the way, Lordship. It does not debar. It opens the way, Lordship.
Your Lordship, let me make one thing very clear. Your Lordship, this Class B homeopathy, it has been taken up as a one-time exercise, Your Lordship.
Yes.
So, because of that, Your Lordship is barred now. Your Lordship, because Your Lordship, if you can you come to Nagaland, Your Lordship,
Exactly, Lordship.
Section 9, close Section 9.
Nagaland Act.
Yes, Your Lordship. 1997, Your Lordship. The Nagaland Gazette Extraordinary April 6. Your Lordship, you can come to my affidavit in opposition also, or whichever. Section 9.
Section 9.
Yes, Your Lordship. There shall be two classes of registered homeopathy, with Class A and Class B. If you can kindly come to Class B, Your Lordship.
Yes.
Class B, Your Lordship. One who has been engaged in the practice of homeopathy system of medicine as the principal occupation for a period of not less than 5 years, Your Lordship, immediately before the date of coming into force of this Act, Your Lordship, provided that the person shall have passed an examination to be held by the board in the manner provided by regulation upon an application for registration of his name to be paid within a period of 2 years from the date of this Act coming into force. So the person has to have a practice. It is been taken as a one-time measure, and they need, with the enforcement of the Act, they need to have a practice of 5 years, Your Lordship, and then the license is state list, Your Lordship. So, Your Lordship, otherwise now they need to have a qualification. It's very clear, Your Lordship.
So it was at that relevant point of time
Yes, Your Lordship.
that they were supposed to.
Yes.
Was it operational in all states of India?
Your Lordship, even in the Central Act also it is written like that.
No,
To
that's
keep the
why-
commencement.
that's
Your
why I'm
Lordship.
saying.
Yes, Your Lordship.
It cannot be just one state or
Yes,
two.
Your Lordship. With the comments,
Even
even the
if it is-
Central Act.
even if
says
it
that.
is a one-time measure.
If I have come to the Nagaland from Nagaland, my opening will come from Nagaland only. Otherwise, the period beyond 1993 to 1997 will not be able to condone by the Central Act or any other state act. Here in this notification, my that privilege has been taken away. Now I will not be able to neither establish myself in Nagaland, and because of that, I will not be able to go anywhere else.
For that, they should have practiced there, Your Lordship. They should be actively practicing here.
Now
They have
that
already made a submission as to how the anomalies has been detected, Your Lordship.
Okay. Yeah. Simple. Yeah. Cool. Yeah. Absolutely. That is complex.
So, Lordship, I would just, uh, I'm almost at my end of my, and almost I will just like to summarize things up, Lordship. My basic challenge, first challenge, Lordship, would, if Lordship would note it down, Lordship.
Yeah.
Otherwise, I have given an argument.
I think you've got your written arguments here.
Yes, Lordship, but just two, 3 points. I would like just
Yeah.
major points, Lordship.
Yes.
The first point would be, Lordship, that a notice, that notice under section 24, that is not permissible, Lordship. A public notice under section 24 is not permissible, and this cannot take, it doesn't have any legal character. If a notice has to be, Lordship would know that land acquisition processes are there. In land acquisition processes, first a notice is issued, and then there is a publication, a specific publication in the official gazette, that this land will be taken up for uh, acquisition. So same process, Lordship. This notice has no bearing. First, it has to be published under section 23, not 24. Now, Lordship, there is another thing. The
Yes.
criteria which has been,
Yes.
the criteria which has been given for us, the petitioners, who are presently practicing homeopathy, that would not cover us, because admittedly we are not practicing in Nagaland, not because we don't want to practice, it is just because we are, our licenses were not renewed. So there is no question. Lordship, at this point, Lordship may kindly see the affidavit in opposition filed by the board. In the affidavit in opposition filed by the board, I would just uh, refer to paragraph number 5. In page number 2. It was filed, it was received on 19/5/2022. Opposition filed by 3, 4, 5, 6, and 7.
1 minute. Affidavit in opposition. Yeah. Page.
Page 2, last para number 5. With regard to the statement made in para 5 of the writ petition, the deponent states that the state in the year 2010-11 undertook the exercise of rehauling the functioning of the state board as well as scrutiny of the registration and renewal of Class B homeopathy practitioners in view of the various issues flagged by the Central Council, which is the board incorporated under Section 6 of the Homeopathy Central Act. In the meeting held on 30/6/2011, it was decided to suspend the state board following discussions of anomalies detected in the functioning of the board of homeopathic system of medicine. It is pertinent to state that a list of names was sent in 2010 by the state register, which was rejected by the Central Council. The list sent in 2010 to CCC contained names of all classes of Class B homeopathic practitioners in the state register, which included the name of the petitioners. Now, Lordship, admittedly, there has been some kind of uh, there were some kind of doubt in the list or functioning of the board, and so the board ceased to function. Now, when the board ceased to function in all these years, the petitioner could not have been renewed. Now, had it been a case, my case, had it been, they would have got a very good case if in the year 2013 they would have renewed me, and then The council said this list is not good, all these may be fictitious persons or the residence may not be true. Then if I was allowed a notice served on me, see the central council has rejected your list, your name, kindly give your verification. That would have been fine. Now, after 2013, 13, 14, 15, 10 years, after 10 years, am I supposed to stay in Nagaland not doing anything? I have to go back wherever I am from or wherever I want to. Can there be any restrictions on me since you have practiced homeopathy class B in Nagaland and 2013 you have not, from 2013 no renewal, so you have to mandatorily stay in Nagaland? Can anybody tell me that? In my humble submission, no one can tell me that you have to stay here. But the thing is that why Nagaland and not anybody? Only thing is that because if my Nagaland is my doorway to practice anywhere else, as my learned friend has already pointed out, I am the one-time settlement holder. After that, I will not be in any way. So if I am not renewed here, then my entire career is lost. So at this juncture that I have been placed into. And the very fact is that I have got no remedy brings this writ petition to picture. When there is no remedy, your lordship is very well aware, writ is the only remedy. I am remediless. Where will I go?
Yes.
Admittedly, the board of dysfunctioning of the board, not because I have, if by chance I have, supposedly I am not from Nagaland and I do not practice in Nagaland, but I have renewed license in Nagaland, there is a flaw in my name. If assuming, I'm not admitting, but if assuming that is true, that has to be looked into by the board, I have no problem. But that should have been looked into as per the list of 2010. You renewed me 2012. Since then, you said no, no, no. Right now, there are a lot of complications happening. So let us wait for some time. Waiting. Because of your wait, my tenure is gone. The statutory compliance you have not done, and then you are restricting me from now entering. Both sides cannot happen. I am not denying the fact that there are no hanky panky. There might be hanky panky, but you look into it. You cannot deny me and then say that now there is no other option. You have pushed me in the well. By waiting, you have pushed me in the well, and now you are saying that this well cannot be climbed. You cannot climb up to the well. That cannot be, in my humble submission, that cannot be the rule of law or any legislative intent. Now, Lordship, the next point, Lordship, with regard to someone who is permanent resident in Nagaland, there might be occasion where I need to put forward my voters list where I am from. That is my identity. But asking that are you from Nagaland? You have to be from Nagaland or else you cannot do it. That in the dominion of India cannot happen. Maybe it's Nagaland, Assam or anywhere else in India. Nobody can ask you are from Nagaland, go to Nagaland. You are from Kerala, go to Kerala. No. Any Indian can practice anywhere in this country, but yeah, there is a step to do that, and that step has been taken away from me. And asking PRC, asking my domicile, is itself not admissible in law. Argiba? Lordship, these are the basic 3 points which needs focus in my
Okay,
case.
tell me, you are the other writ petitioners, all your...
No, I'm only for item number 9.
What?
Lordship, I have been newly engaged, Lordship, some 6 months back.
What about the other 10, 11 and 12?
Your Honor, in WBC number 260 of 2021, I am assisting Kalyan Kumar Chakrabarti. But in other writ petitions, I am not in the case.
The other is being appeared by, again, Kalyan Kumar, Your Lordship.
Yes.
Where is
Based
he?
in Kolkata, it seems that he has to come in VC, but I don't know.
I think I granted permission VC.
Yes.
I have sent the link, but he doesn't know how to do it.
See, we have sent the link also.
Yes.
I don't know where he is. Then this,
Otherwise, my lord, this page of writ petitions is similar to WTC number 180 of.
no, that's fine, that's fine.
Yes, Your-
But then he may have some other points, isn't it?
Yes, my lord.
Um,
See, practically because I'm sitting for 1 week.
yes, sir.
And rest 1 week or so, I have very limited time because of other administrative works also. Now, we have wasted so many hours in the first half in the morning, second half.
Lordship, they are saying
I
basically it is
I can't keep it part-heard.
If I may suggest, Lordship, they are saying that it is covered, almost covered the arguments which has been made in 180.
Is he covering your argument?
Yes, my lord, in WTC number 2.
Can you talk to this gentleman, Kalyan?
Yes,
Come back then.
yes, yes,
I'll wait for some time. You talk to him.
yes, yes.
If he wants to appear through VC, I've given him the link. Discord
Yes.
registrar sent him the link. He's not joining.
Yes.
For what reason?
I'll
Just
talk to him also.
talk to him. In this, just say, I don't know, I'm not reserving it. Item 6 and 7, petitioner will be Takakichu. Huh?
Lordship, this a judgment they have given regarding domicile. And one more thing, Lordship may just note, Section 2 of the Nagaland Land Revenue Regulations do not permit anyone from outside the state of Nagaland to.
Yeah, that. Item 1 also, I don't know who's the respondent. Which petitioner went to Supreme Court?
Petition
180.
180.
Your petitioner went to Supreme Court.
My petitioners went to Supreme Court. I came to know only after the order has been passed. Lordship, I have been practicing for last 10 years in Gauhati High Court. I would never
I know.
suggest anything against.
I'm not casting any aspersions on the council, but your good name, please?
See that, Lordship.
P. Dega. Okay. This is just going to be a lot of confusion. For the respondents in item 6 also, we don't know who's appearing.
Yes, your lordship, item 6.
6, Lordship, I'm appearing on 6. In 6.
No, 16.
9.
No, respondents.
Respondent.
Any CGC is available?
No, your lordship, as of. Previously, it was appeared by Kamai.
No,
Anil,
but
by-
I'm told that he has sent it over the file.
Yes, your lordship.
Oh, 6 and 7 argument has been done in the morning.
No. 6 and 7 is concluded.
Yes, yes. For
Only thing
petitioner's
is
side.
6, the respondent party is not present.
Oh, yes, yes.
Then in your case, 180, both sides are present, there's no issue.
Yes.
But then 8, 10, and 10, 11, and 12, petitioner's counsel is not here.
Lordship may indicate that since the matter has been called for twice or thrice, the presence was essential, so Lordship may carry on forward with that. And also the batch of writ petitions are similar. This is just what I want to suggest.
No, these are all these petitioners. Item 7, they are from Tamil Nadu.
Yes.
Your writ petitioners, they are from different
Different
states.
states.
From the name, it suggests that they are some of them are from Kolkata, others from Delhi, and others from Gujarat.
My lord, I just spoke to him, so he's trying to connect with the link, but he's unable to connect with the link also. So he wants to argue the matter.
He wants to argue the matter.
Yes.
Then where is he?
The direction has been given your ship on the last day that he should come personally, your lordship. But intentionally, he is actually coming on the VC.
Also, may I kindly see the last order?
Last order
Which,
also.
on Friday.
Which case
Thursday.
was it passed?
In all the cases, probably. 226, Lordship may say 226.
They seek for permission for VC, but the court says no, let him come personally in the court. I don't know whether it's reflected in the order, Your Lordship, but that was what this honorable court has said.
Who is the last order passed? I don't see any orders. Is it in the first item?
226.
Is it in 226? No, 226 also.
I think it will also be.
When was the last time it came up?
Last time.
It's a 2021 order only. Give me the first item, 152. 10/8/2023. I think this is the one.
10th of August. Tenth of August.
Are you available on day after tomorrow?
If Lordship, I would be. Oh, you have problem?
Your Lordship, if it can be on Friday.
Friday is
Otherwise, Your Lordship, more or less, it's.
Friday is my last working day.
Lordship, then Thursday, Lordship.
Interesting.
Thursday, Lordship can fix it. Or Wednesday, I'm fine with anything.
Okay, Your Lordship. Since there's an urgency, I mean, there's a direction from the Supreme Court, so we don't have any problem.
I have no idea whether this court will be sitting long.
Yes, my lord. I understand the difficulties also since there is a direction from the Supreme Court also. And my lord, since this matter relates to
Where is the Supreme Court order? I saw it the other day.
Lordship, as per the Supreme Court order, it is for 3 weeks, which will expire on 18th. 18th of August.
Order dated
24/7/2023.
24/7 or 28/7?
28/7.
Twenty 28/7.
On 18th. Whatever Lordship pleases, if
my lord, I did not seek for adjournment since there is a direction from the Supreme Court.
So now I'll close the arguments.
Yes, since I am appearing, my name is reflected in WPC number 260. The ground of challenge in WPC 180 of 2019 and WPC 260s are similar on a similar point. The contention as well as the ground of challenge. Because in WPC number 260 also, the petitioners are challenging the impugned notice dated 10th August
2016.
2016.
No, that's fine. That's fine. Only issue is the councils.
Last time also it was
I will
absent.
not seek adjournment on behalf of Kalyan Chakrabarti also. Because since in WPC 260 my names are reflected.
Lordship, if I may, if Lordship pleases, this matter will can be taken up on 17th. I would from myself, I would prepare the argument so that Lordship is very convenient for your Lordship to pass an order. that can be done.
17th will be difficult.
I'll also deliver a soft copy. That'll be beneficial for.
Okay, take down. But Mr. Takakichu, Learned Counsel for the petitioner in WBC number 152 of 2019 and 226 of 2018. Stop. Also heard Mr. B. Decker, Learned
P. Decker,
Counsel, P. Decker, Learned Counsel for the petitioner in WBC 180 of 2019. But you are not assisting Kalyan in the other two cases.
Yes.
Then what do you do then?
My lord, I'm appearing only in item number 12, 260, since my name is reflected in my name is there in the case. Otherwise, in other.
Also heard Yingkong Jamir, Learned Counsel for the petition in WBC 260 of 2021. Sapara. Heard A. Zimami, Learned Counsel for the respond number 1, and Mr. Limapong, Learned Counsel for respond number 2 in WBC 226 of 2018, and MS Livika, Learned Government Advocate for the respondents in the other writ petitions. Stop. Sapara. None appears for the petitioner in WBC 108 of 2019 and 5 of 2020, despite sending the VC link.
47 also, Your Lordship, 47 of 2020 also.
Okay, 47 of 2020, despite sending the link to the Learned Counsel for the petition, sending the VC link. Stop. As a last chance, please the matter again on 17th. You want it on 17th?
No, Lordship, I will provide a soft copy of the arguments. That can be concluded, Lordship. The argument can be concluded.
Meantime, you ask him whether you can appear for in respect of the other writ petitions.
My lord.
If he is not able to appear.
Yes, without the authorization from the client in the other petitions, I will not be able to appear also. But since all these are analogous matter, it is challenging the impugned notice only, and the ground of challenge is to us.
However, Your
Since he
Lordship,
wants to appear personally,
there might be a chance that he will later on say that he has not been given a
There's a whole thing.
report.
As a last chance, Sapara, to the Learned Counsel for the petitioner in WBC 108 of 2019, 5 of 2020, and 47 of 2020. Before, as a last chance to say, there's already a direction from the Honorable Supreme Court, order dated 28/7/2023, that this matter should be disposed of within a period of 3 weeks from the date of issuance of the order. The said 3 weeks expires on 18th of August 2023. Then after that, they say, as a last chance to the Learned Counsel for the petitioner in WBC so-and-so, list the matter again on 17th.
Lordship, in item number 9, arguments are concluded.
Lordship, I may give a rebut little bit. I mean, it has been covered intensively by my senior counsel. We were like herring a little bit. I think that will do.
Practically everything is covered. If you want to give the soft copy or whatever you want to do it on 17th.
All right.